Good morning, everyone. Can someone just unmute your mic for me just briefly and just tell me if you can see the slides and hear me okay?
Yes.
Okay, great. Thank you for that. Okay, we're going to continue on here with Module 10. I'm just going to try and make this a little smaller here. There we go. Okay, so if you remember from last class, we were discussing the criminal justice system, chapter 13 in your textbook. For today, we're going to continue with that. I'll just do a quick review of what we discussed last class, and then we'll move into the last two parts of the criminal justice system, being the court system and the correction system. And I'm going to try and finish up about 12 minutes early. There's a video on here you can watch on your own time. We're not going to watch it on here, so I'm going to try and give you some time to watch that at the end. One thing to note, someone had asked about the new grading system that was, there's a media release done by the university. I've received an email from the Department of Justice Studies, and they're still seeking clarification on one part of that from the university. So I'm not going to comment on that today. As soon as I get clarification from the Department of Justice Studies, I'll post the information to the news forum on UR courses, and then we can also discuss that next class like this on Zoom. I was kind of expecting to hear back yesterday, but I didn't. So I will follow up today with regards to that. So we'll just move right into it here. We'll just review what we discussed last class. Briefly, we'll go very quickly and then into the new material. Okay. So we discussed last class just the different definitions of crime, whether it be from a legal definition or a behavioral definition. And we decided for the purposes of this class, we would define crime as an act or omission regarded by a sizable segment of a given society as warranting formal intervention to control, punish, and prevent such behavior. So remember, a crime can be an act or omission. Either someone did something they shouldn't have done, or they omitted to do something they should have done. And then we discussed theory briefly, specifically structural functionalism as it pertains to our criminal justice system. And remember, structural functionalists, this is right from your textbook, define criminal law as a system of rules developed collectively by legislatures to protect all members of society equally. And I posited that that is what we're dealing with today with our criminal justice system. That is the way our criminal justice system works. We also examined conflict theory as it pertains to the criminal justice system. And remember, conflict theorists look at our criminal justice system quite a bit more critically, and they believe some laws target behaviors of less powerful individuals while ignoring much more harmful behaviors committed by individuals of power or corporations. And we discussed white-collar crime versus blue-collar crime, price fixing, and that sort of thing. So that was conflict theory as it pertains to our criminal justice system. And then we got into social control, and essentially the criminal justice system is concerned with social control. And recall we discussed two different types of social control. One was informal social control, and one was formal. And remember, the relationship between the two is inverse. So informal is simply actions, words, influences from our parents, from our peers, that sort of thing that influence our behavior, that make us want to not commit crime informally. Whereas formal social control is based on the legal definition of crime and involves official parameters created by legislatures, and that would be your police, courts, and corrections. So that's formal social control. We're formally controlling the way people behave while ignoring much more harmful behaviors committed by individuals. Someone just got their mic unmuted there. Thank you. And then we got into talking just briefly about the three main types of offenses, and this again goes back to our law lecture, but the three types were indictable offenses, summary offenses, and dual offenses, also called hybrid offenses. Remember, the indictable offenses are your more serious criminal offenses like murder. Your summary offenses are your less serious offenses like causing a disturbance by yelling, something like that. And then your dual offenses or your hybrid offenses are where the offense is both indictable and summary, and the Crown prosecutor elects how he or she is going to proceed in court. So they can proceed either by way of indictment or summarily. They get to choose. And that is the overwhelming majority of offenses are the dual offenses. So those are your three types. Again, this is a quick review. Then we got into measuring crime. So we discussed the Uniform Crime Report, or the UCR, and just an annual standardized collection of crime that's brought to the attention of the police. And remember, when we discuss crime, we're only discussing reported crime. So when we hear in the news the crime rate is up or the crime rate is down, what that's really saying is the reported crime rate is up or the reported crime rate is down. And we'll talk about the unreported crime on the next slide. The other point there was the hierarchy rule, where if an incident involves two different offenses, only the most serious is counted. So if there's a murder and a theft, the theft won't be recorded in the stats, only the murder. So it's a bit of a skewed view of what crime is actually occurring. Another way to measure crime was through the use of victimization surveys. And on the next slide, we can see that there's some reasons victims won't report crime. So these surveys give us a better idea about crime that occurs that is maybe not reported. Some of the reasons we discussed for victims not reporting crime can be the subtle nature of crime. Maybe the victim doesn't perceive the offense as a crime. Sometimes the offender is a family member or a friend or an acquaintance, and the victim doesn't want to get that person into trouble, so they won't report the crime. Victims sometimes believe that the incident was very trivial, and the penalty that could be received is either too harsh or not. It's not worth it. So that's another reason. The victim fears for their safety if they report the crime. Maybe they're involved in some sort of gang, and if they report a crime against another gang member, there will be retribution against them. So sometimes that plays a factor. In some cases, the victim may himself or herself be a criminal and or don't trust the police. The victim doesn't want to report the crime for that reason. And in some cases, the victim is simply embarrassed. And those are just a few. There's other reasons, but that's a handful of reasons why a victim may not report a crime. And when we discuss crime that isn't reported, we're talking about the dark figure of crime. So the dark figure of crime is simply crime that occurs, but it is not reported to the police. So that's an important thing to note. I would note that definition of what is the dark figure of crime. Crime that occurs, but is not captured when we measure crime because it's not reported. So the slide here says criminologists estimate crime is actually 4 or 5 times more than what is actually reported. Sometimes they say it's 1/3 to 2/3. Just know that different studies will give you different results. The majority of crime goes unreported. That's the bullet point of this. So also the dark figure crime discusses that some crimes are never talked about because it's a taboo subject. And one example is male survivors of the crime of incest. So those are some reasons why crime is not reported to the police, and that crime that is not reported is referred to as the dark figure of crime. And I know we're going quickly here, but we've got a lot to get through. So this is just a review from last class. And again, remember, everything that we discussed here, this whole lecture will be posted again to YouTube if you want to review it again later tonight. The next topic we discussed was the criminal justice funnel. And all that means is simply the actual number of crimes committed in Canada compared to the actual number of people who are incarcerated in a federal penitentiary. And it's approximately 1%. So less than 1% of people who commit an offense will actually end up in a federal penitentiary. And we'll just go briefly through why that occurs. So when a criminal offense is committed, is that crime reported to the police? And as we just discussed, the overwhelming majority of times it is not reported. So that funnels out approximately, 2/3 or more of crime right there. It's not reported to the police. If it is the third or so that is reported to the police, do the police deem that to be a founded crime? Is it an actual crime that has occurred? And if it does, if the police do deem it to be a founded offense, is an arrest made? Are they able to make an arrest? Once an arrest is made, does that person actually go to court? Does that person get sent for a trial? There's a lot of things that can occur between an arrest and a trial that include alternative measures, or what we would call pre-charge mediation, where before the crime, or pardon me, before the charge is read out in court, they go to say alternative measures or something like that. So they never actually go to trial a lot of the time. If it does go to trial, is the accused person found guilty? A lot of people that go to court, they do not get found, they get found not guilty, and of course they would not serve any jail time for that. So the person has to actually be convicted. After that, the judge can decide whether or not that person is going to actually serve any time in a prison. There's a number of other options, including electronic monitoring, which is house arrest, community service, paying a fine. The spectrum is infinite. There's all sorts of things besides prison that can occur. And then finally, if the judge decides that person will go to jail, then they would go to prison. But like we said, that's about 1% or less of actual crime. People that commit crime actually go to prison. So that's essentially the criminal justice funnel. You can call the crime funnel as well. And we got into just some crime reporting. I'm not going to go through these again in too much detail, but you can, on the first one, you can see how crime kind of peaked around 1994 and then was in steady decline until about 2014. After 2014 into 2015, if this graph is extended, we'd see that crime is actually going up across Canada, not just in Saskatchewan. That's occurring right across Canada. And there are a number of reasons for that. Just a few more charts you can go through again on your own. We already went through these last class. And measuring crime and mapping crime, I just left a link there if you'd like to click it. It takes you to the Regina Police Service website where they actually have a crime map posted. And you can see where the hot spots, so to speak, are for crime in Regina. So it goes from green, light green, which is very low crime, and then into the yellow, and then some spots are actually red. And that's where the most crime, the most reported crime, of course, occurs in Regina. I'll let you click through that on your own. And then we got into perspective, perspective and models of the criminal justice system. And we discussed three: the crime control model, the due process model, and the restorative justice model. And as I noted, most scholars in Canada argue we have a blend of all three of these models. So we'll just review these just briefly. And the crime control model, the bullet point of this is emphasizing control of dangerous offenders through quick arrests and convictions. Essentially, what they want is harsh penalties to deter others. That is the point of this crime control model. And I think I mentioned last class that some people would view a high number of arrests as a successful crime control measure, but when we have a high number of arrests, we also have a high number of crimes, because the arrest symbolizes the fact that we weren't able to prevent the crime from occurring in the first place. So personally, I would say a high number of arrests is not a good measure for how successful a crime control model is, because it doesn't take into account that we failed to prevent the crime from occurring in the first place. So that's just one thing to note regarding that crime control model. And then we got into the due process model, and that emphasizes individual rights and constitutional safeguards against arbitrary or unfair judicial or administrative proceedings against a person. So it's really concerned with procedural justice and the importance of the Charter of Rights and Freedoms. So that's the due process model. If someone is accused of a crime, put them through the system is fair, everyone is treated equally, let it run its course, make sure everyone's rights are adhered to, and the correct decision will be made in the end according to this model. So it really relies on the process, not so much on the punishment. And the last one we'll just touch on briefly is the restorative justice model. And we're, again, not going to get into this too deep, because all of next week we're going to discuss restorative justice. That's the last topic for this class. The main goal, of course, is a systematic response to wrongdoing that emphasizes healing. So that's the key of restorative justice, healing the wounds of victims, offenders, and communities. So those are those three groups again: victims, offenders, and communities coming together and realizing the harm that was committed by committing the crime. And it really emphasizes healing and reintegrating the offender back into the community. It does not focus on punishment. So that is restorative justice. And we'll get into more of that in much more depth next week. Then we got into drug and alcohol use. And of course, it's not a surprise, but there's a strong positive correlation between drug use and criminal offending. And the numbers from your textbook were 280% to 380% higher chance of a drug user committing criminal offenses over a non-drug user. So that's substantially higher. We discussed there are 3 drug-related pathways to criminal involvement. And the first one was the Psychopharmacological Pathway. And that simply states the reason people get involved into a crime is because of the biological influence the drug has on the person's body. Essentially, they ingested a drug, and the actual biological effects of that drug cause that person to commit a crime. It's nothing more complicated than that. The second one was the economic compulsive pathway, and that involves a person committing a crime in order to directly obtain drugs or to obtain money or property that can be used to purchase drugs. So essentially, stealing property. Someone maybe commits a break and enter to a garage, steals a bunch of tools, and trades those tools for drugs. That would be what this pathway is discussing. Someone steals a car and trades that car for $500 to buy drugs. That's it. That's what this one is saying. And the last one was the systemic pathway, which involves participating in the illicit economy, which is the drug market, to get drugs to clients. That involves turf wars or drug territory. And we discussed right here in Regina, obviously, some of the bigger drug dealers will tax the smaller drug dealers in exchange for allowing them to sell drugs in their drug territory. So the little guys sell their drugs, but they give a cut of that money to the bigger drug dealers. That is essentially a drug territory. Lots of turf wars that occur in the drug market, drive-by shootings, that sort of thing. People are selling drugs where, according to the other drug dealers, are not supposed to be selling drugs. That's a systemic pathway. We did discuss, in my personal opinion, the first one obviously does exist. Do people do things because of a biological influence? Yes, absolutely they do. However, the last two, I would say, are much more prominent in today's society. A lot of people get into crime to support an addiction. They're not hardened criminals, they're not violent. They're simply committing property crimes in order to feed an addiction. And so that would be your second one. And obviously the third one is for profit. And obviously drugs are big business for gangs. And so that one is also very prevalent today. The last point on there that's not on the slides, but we discussed the way drug trafficking is viewed in different countries. And we discussed how drug trafficking is viewed in Canada versus the United States versus the Philippines. Canada takes somewhat more of a restorative justice approach, including the drug treatment court that exists right here in Regina. The United States, kind of in the middle, hands out substantial jail sentences for drug trafficking. Folks can go to prison in the United States for years and years, decades and decades for trafficking in drugs. And the Philippines, drug traffickers can be killed by a firing squad, capital punishment for drug trafficking. So when we discuss the effects of drugs on people and in the criminal justice system, just kind of take a bigger global perspective and understand it's not the same view across the world with respect to drug trafficking. And we'll keep moving right along here. There we go. So we just got into the goals of the criminal justice system. And obviously, the personnel that work in the criminal justice system are tasked with providing formal social control. They're not concerned with informal social control. The overarching goal of the criminal justice system is to reduce crime using formal social control. So I would think that would be important when we discuss the criminal justice system. What is the actual overarching goal of this criminal justice system that we all live in? And that is to reduce crime using formal social control. And one way is through the use of sentencing provisions in the Criminal Code of Canada. I just put the section number there, section 718 of the Criminal Code. And the main points of section 718 is the punishment should fit the crime. It has to be proportionate to the crime. You wouldn't sentence someone to the same fine for stealing a bag of chips from the 7-Eleven that you would for stealing a car. They're not the same thing. Another sentencing provision is deterrence. And what we want there, what the court system will want is to sentence a person for committing a crime, and then have another person look at what happened to that person and say, oh, I don't want to be involved in that. I don't want that to happen to me, so I won't commit the same crime. So that's all deterrence is. And then incarceration, of course, only when necessary to ensure public safety. We don't want to be locking people up who do not pose a threat to public safety. And then now we focus we shifted our focus to the structure and the components of the criminal justice system. And of course, there are three main components or institutions that make up the criminal justice system, being the police, the courts, and the corrections. And I put up a little diagram there. This is an American example, obviously. But it starts with the actual crime being committed on the left-hand side and just working your way through the criminal justice system and the different ways, the different outcomes that can result. So I'll let you look at that on your own. So the first component we discussed in the criminal justice system is the police. Remember, the police have the responsibility to investigate alleged criminal offenses. That's their primary business. They obviously apprehend suspected criminal offenders, so people who commit crimes are arrested by the police. They assist prosecution with obtaining criminal convictions in a trial, and the way they do that, and this somewhat overlaps number one and number two, number one being the police, number two being the courts, but the overlap is after the police have made an arrest, if that person goes to trial, the police officers involved in that investigation will testify in court about what they've seen, what they did, what the other person, the accused person did, and so on. So police officers find themselves in court regularly testifying in a criminal trial. The police are also tasked with keeping the peace in a community, preventing crime. Obviously, we discussed that. Crime prevention is very important. We're not going to get into that too much in this class, being a 100 level class, but there's a whole wide range of crime prevention models and tools that are accessible to the police. The police do provide a lot of social services in the forms of, for example, child protection, assisting social services, assisting other provincial groups in the social service world. So that's a big part of it. And also upholding constitutional protections. So such as your right not to be arbitrarily detained, security of the person. Obviously people can't, if you're in your house, people can't break into your house. The police will enforce that law. We discussed a number of different types of police organizations in Canada and also in the United States, as some are more prevalent there than here. But basically, we're looking at municipal police agencies in Canada. Examples of municipal police agencies would be the Regina Police Service, the Saskatoon Police Service, the Calgary Police Service. They are primarily responsible for enforcing laws in a city and generally don't venture too far outside of the city. Not so much in Saskatchewan, but in Ontario, regional police services are popular. Regional police services such as the Peel region, which is around Toronto, essentially. The Mississauga region is Peel. There's Durham Regional Police. They're responsible for a larger area than just a city. So that's all it is, just a region that they police. Provincial police services exist in Ontario, Quebec, and Newfoundland in Canada. We have the OPP, the Ontario Provincial Police in Ontario, we have the Sûreté de Quebec in Quebec, and we have the Royal Newfoundland Constabulary in Newfoundland. So those are provincial police agencies. Generally speaking, provinces contract the RCMP, the Royal Canadian Mounted Police, to provide rural policing services. So for example, in Saskatchewan, we have 5 or 6 city police, municipal police organizations, and in the larger centers, and then the rest, the smaller towns and the rural areas are policed by the RCMP. So that's on a provincial contract. Not to be confused with the RCMP as a federal police agency, which they are. So the RCMP is the only federal police agency in Canada, and they are responsible for enforcing laws across Canada. If you're a member of the Royal Canadian Mounted Police, you have police powers in BC, the same as you have in Saskatchewan, the same as you have in Ontario. So right across the country. We talked about tribal police a little bit, university and college police services, more popular there in the United States, where they'll actually have a university police service that polices the university and the immediate surrounding areas. Not, to my knowledge, very popular or very common in Canada. We talked about wildlife and conservation officers being peace officers. Remember that, not police officers, peace officers, which is a definition in the criminal code that gives them powers of arrest, and they're able to enforce laws, specific laws. We had one question last week that discussed or asked about, what about the CP rail police or the CN rail police? And of course, they are police officers with limited powers to enforce laws that pertain to railways or the immediate surrounding areas around railways. You won't see a CP rail police officer enforcing any laws away from a rail yard generally. So those are just some examples of different police organizations that exist in Canada. Of course, what we're talking about there is jurisdiction. So that's kind of a big thing. A member of the OPP, the Ontario Provincial Police, would not be able to enforce laws outside of the province of Ontario. They're sworn in to enforce the laws of the province of Ontario, not Manitoba or Quebec on either side. So we're talking about jurisdiction there. And then we'll move along to a typical criminal justice process, and we gave an example last class. We're not going to harp on this too long. But generally speaking, the typical criminal justice process would involve a crime being committed, and usually a witness or a victim will phone the police and make a complaint of whatever the crime was. Someone broke into my garage. Someone's in my garage right now in the middle of the night, that sort of thing. That's the initial call. The police attend and conduct their investigation. And remember, that can be a very quick investigation that can involve 15 minutes on the scene, or it can involve months and months and months. In the case of someone who broke into a garage in the middle of the night and the police arrive and that person's in the garage trying to steal the car, an arrest is going to be made right away, and that's going to be the bulk of the investigation. Whereas these very complex bank frauds, where sophisticated groups are really using elaborate schemes to defraud people of money, usually a commercial crime investigation unit, a fraud section, if you will investigate those crimes, and that can take months and months and months. So investigation can be quick, or it can be very drawn out. After the investigation takes place, an arrest is made and charges are filed. So essentially, remember, after someone is arrested, they're either released with a court date or they are remanded into custody. And remember, remand, we'll talk about this coming up, but that's just simply someone who is held in custody before their trial because they either pose a flight risk or a danger to the public. And then we got into the fact that police operate in a very highly visible and political environment. We discussed some of police operations are very overt. Uniformed police officers wearing uniforms, driving marked police cars. And there's also the covert side where you have no idea that the person you just passed on the sidewalk is a police officer. They don't look like a police officer. They don't dress like one. And they conduct covert police operations. So there's both visible and not visible police operations. And that's where we ended last class. So I know that was quick, but again, that was just a brief review just to kind of bring us up to speed here. So now we'll get into the court system, which is the second component of the judicial system, the criminal justice system, rather. And a few responsibilities of the court. So the first one I put up there is determine guilt or innocence. And I probably shouldn't have used the word innocence because we're not determining guilt or innocence in a court system. What we're determining is guilty or not guilty. And remember, just because someone's found not guilty does not necessarily mean they're innocent, but they're not guilty for whatever reason. Remember, we talked about the burden of proof. Are they guilty beyond a reasonable doubt? If they're not guilty beyond a reasonable doubt, then they're, by definition, not guilty or not criminally responsible, again, with respect to either the actus reus or the mens rea. Remember, the guilty mind. If someone can't form the criminal intent to commit the crime, just because they did do the actus reus does not mean they're legally guilty. So that is something to bear in mind. But for the purpose of this slide, guilt or innocence of suspected offenders at a trial, which is the adjudication. The judge obviously is responsible for ensuring the trial goes on. Sometimes the judge is referred to as the trier of fact. He or she is responsible for hearing all the facts and making a decision. So that is one responsibility of the court system. Another responsibility is to sentence those found guilty to some form of punishment. And there's a whole wide range of sentences that can occur in a court system. On the very lowest end is something called an absolute discharge, where someone is found guilty of an offense, but they receive no criminal record, they receive no fine. Essentially, the court acknowledges they are guilty, but for whatever reason, they will not receive a criminal record, they will not go to jail, nothing like that. Sometimes one little step up from an absolute discharge is a conditional discharge, which is somewhat common on first offenses, that sort of thing. And all that means is it is also a discharge, but it's conditional on something. So what it might be conditional on is something like, you don't get caught committing a criminal offense in the next year, for example. You stay out of trouble for the next year, and this conviction will go away. You will receive no criminal record, that sort of thing. It's on the very low end of convictions. Usually for a first offense or a more minor offense, you'll get your absolute discharge or your conditional discharge. On the other end, we have life in prison. Very few offenses carry that much of a sentence. Obviously, first-degree murder would be one, where someone is sentenced to life in prison with no eligibility of parole for usually 25 years. So that's on the other end. And then in between, of course, there's so many other possibilities the judge can sentence that person to. Usually it's some sort of probation or conditions to follow. So maybe that person doesn't go to jail, but they're on probation for 18 months where they have to abide by a number of conditions. If they don't abide by those conditions, they're the word we would use is breaching. They're breaching their probation. They're breaching their release order. Some common conditions that would go on to something like that, onto a probation order, would be always not committing any criminal offenses. The way it's worded on a probation order is usually to keep the peace and be of good behavior. And all that means legally is if you committed another crime, you're not being of good behavior, you're not keeping the peace. So that is on every single probation order. And then there'd be other ones, maybe this person's out doing garage break and enters in the middle of the night. Always at night, they're always out when people are sleeping, breaking the garages. Maybe an applicable condition would be that a curfew would be placed on that person. They have to be in their house between 10 p.m. and 7 a.m. That's just an example of a curfew. So if they only commit crimes at night, maybe they're placed on a curfew. Another thing is maybe the person only commits crimes when they've been drinking or using drugs. When they're sober, they don't bother anybody. So maybe an applicable condition in that case would be to abstain from the consumption of alcohol and drugs. So I'm not saying those are absolutes or those occur all the time, but those are some common conditions that a judge may place on somebody who is convicted. A probation order is a sentence in an attempt to try and keep that person out of trouble for a certain period of time. Usually a year, 18 months, 2 years is probably on the high end. It's usually in that 12 to 18 month range, maybe 6 months on the low end. Another responsibility of the court system is to interpret laws made by legislative bodies. So remember, the court system is responsible for interpreting those laws. The legislature makes the laws, and the court system has to interpret and apply the laws. So for every question that comes up, remember, the jurisprudence view of law will say that court system will interpret the laws correctly and have an answer for every single question that will arise in a trial. The court system also sets legal precedents. So remember, that's your case law that we discussed. The court looks at previous trials, previous similar offenses, and what those trial judges did, and attempts to somewhat mimic that given the circumstances. If they're totally different situations, that doesn't maybe apply. But they set legal precedents, and then going forward after the judge sets the precedent, the next judge in a similar situation will go back and look at the precedent that was set by the judge. So legal precedents come out of court for sure. And of course, upholding constitutional protections. So everyone has constitutional protections, the Charter of Rights and Freedoms. And so an example of that, let's say someone committed a crime and were never read their rights to counsel. They were never given the opportunity to call a lawyer. They were never told they don't have to give a statement, that sort of thing. That would be a violation of that person's charter rights, and that may find that person not guilty based on that procedural error, essentially as a procedural error that occurred in that example. So I know I said this last class, and I'm going to just repeat it, but everything I discuss in this lecture should not be taken as legal advice, nor should it be taken as like the absolute gospel in every situation. I'm just simply saying what I have found in my experience. Don't take these things as, well, every time something happens, this will happen. Every time something else happens, you know, they're not, these are not absolutes, but just a general discussion, I guess. So upholding the constitutional protections of citizens is extremely important responsibility of the court system, and a protection for everyone as a Canadian. You know, if you are arrested and you go to court, that court has the responsibility for ensuring your rights were protected. There's always two sides to this, and some people will say to me, well, what about the rights of the victim? The court is really hammering, oh, the bad guy didn't get this, or the bad guy wasn't allowed to call a lawyer. But what about the rights of the victim? And it is a balance, obviously, but at the end of the day, the constitutional protections that every Canadian has, they're an absolute, they cannot be violated. So the court has that responsibility for upholding the constitutional protections that are guaranteed to all Canadians. And then we're going to move into, you've seen this slide before, I just put it in there again, just the overall hierarchy of the court system in Canada. Remember, at the top, the Supreme Court of Canada is the absolute top court in Canada. Most first court appearances for a criminal trial occur at provincial courts there at the bottom. Provincial courts hear first appearances. At the first appearance, generally the person will plead guilty or not guilty. And then that court is set, apparently that is set for a trial. Usually the trial occurs at provincial court as well. In the more serious cases, the trial will be heard at the Court of Queen's Bench. So a lot of your murder trials, that sort of thing, will be heard at the Court of Queen's Bench. That's a higher court. But generally the provincial court handles most criminal trials and certainly most court appearances. I put in here some notes. Similar to policing, courts have evolved and adapted in Canada to include Indigenous people's perspectives. And we've talked about Gladue reports. Remember, that occurs at the sentencing phase, where a person of Indigenous backgrounds history is taken into consideration by the judge. So that's what that means. We've been over that quite a bit. A typical criminal justice process here, I just laid this out. So preliminary hearing, usually just called a prelim, and all that is generally a preliminary hearing. A prelim does not occur at every criminal trial, usually more serious ones, but all that is essentially the Crown presents evidence to the judge, and the judge determines if there is enough evidence to actually take this to a trial. So it's kind of like a trial before a trial. And again, only for the more serious offenses, murder trials, that sort of thing, armed robberies sometimes, where there'll be a trial just to see, is it worth, it's not the full-blown trial, it's just, here's a lot of the evidence we have, and the judge will say yay or nay as to whether we have enough, or whether the Crown has enough evidence to take that to an actual trial where it's going to be the full-blown trial. Someone will appear at an arraignment, and they will plead guilty or not guilty. If they plead guilty, they'll be sentenced by the judge. Maybe not that day, but essentially they're saying, yeah, I did that. If they plead not guilty, it'll be set for a trial. We look at bail hearings, and that is simply people who receive bail. They're out on bail, so they are not remanded in that case. They're released with a future court date. Plea negotiations. A lot of times the Crown and the defense we talk about plea bargaining, and the fact of the matter is the reason for plea bargaining, well, there's a number of reasons. One is, I don't think it's a secret that the Canadian justice system is absolutely backlogged. It is backed up it can take years for a trial to work its way through a court system. Usually after the first appearance, if someone is arrested, usually the first appearance is, say, 2-3 weeks down the road, they plead guilty or not guilty. And then that can, after they do that, it can take months and months and months and months. So if that person is willing to plead to a lesser included offense, the Crown will often take, I shouldn't say often, can consider taking that. So an example, and I think we discussed the 3 levels of assault already. And I'm not going to test you on these, but just understand there's 3 levels of assault: a level 1 assault, a level 2 assault, and a level 3 assault. Remember, a level 1 is just a common assault. Section 266 of the Criminal Code, assault. Someone punched someone else in the face. The level 2 is either assault with a weapon or assault causing bodily harm. And that would be maybe someone hit someone with a baseball bat. That's assault with a weapon. That's a level 2 assault. And a level 3 assault is an aggravated assault. And that is, remember, 1 step shy of an attempted murder. That is a very serious, aggravating assault where maybe someone is maimed or critically injured in an assault. That's just one fine line below an attempted murder. So those are your 3 levels of assaults. And the one below is always included, so in the one above. So for instance, assault with a weapon is a lesser included offense in an aggravated assault. A common assault is a lesser included offense in both of those. So let's say someone is charged with a level 2 assault, which would be, say, assault with a weapon. If they're willing to plead guilty to a common assault, which is the lower level, sometimes the Crown will take that. Even though, yeah, they did commit an assault with a weapon, but they're willing to plead to common assault. The sentence will be less. The Crown will sometimes take that. There's another reason sometimes plea bargains are taken, and that is to spare a victim of having to go through a trial, having to testify against the accused. That can be very painful for a victim to even face the offender. They sit in the witness stand, have to look at this person who did something to them. It could be traumatic. And to spare that victim from having to testify in court, which if you don't testify in court, it can be very stressful. It's a lot of people are looking at you. It's quite the process. A lot of people are not comfortable testifying in court. And especially if it's a violent offense or that's going to cause some sort of trauma to the victim, if the Crown can get a guilty plea from the accused person and spare that victim from having to go through the trial, that's one other reason the Crown may look at negotiating a plea bargain. So those are two reasons there, to kind of speed up the backlogged justice system, and another reason is to spare the victim from having to go through the whole process, which would maybe re-victimize them, actually. So those are two reasons for pleas. Trial setting, generally speaking, it's the Crown prosecutor, remember, is simply the lawyer acting for the state. That's the Crown prosecutor. And on the other side is the defense lawyer. And then we have a judge. In more serious criminal offenses, the accused can select either appearing before a judge alone or appearing before a judge and a jury. And generally those are murder trials where the accused person wants a jury as well. And they get to pick. But generally speaking, in the overwhelming majority of cases, it's the Crown, the defense, and the judge, and they will go through all the elements of the offense. They call witnesses. Someone witnessed a crime. Sometimes they'll give a witness statement. They'll testify before the court. Generally speaking, if it's the Crown's witness, obviously the Crown will ask a bunch of questions. Just tell me what you did, this and that. You say your piece about what you did, and then the defense has an opportunity to ask you questions as well. And what we call that is a cross-examination. And so where the defense lawyer gets to then examine and really clarify points about what the Crown's witness has said. So after the witnesses testify, like I mentioned, police officers will be called and they'll testify about what they did. Generally speaking, what the court's looking to hear from police officers is the procedural end of it. Were the proper procedures followed? Was the accused person given their rights and warning, that sort of thing? The police officer will testify about what they did. Again, can be cross-examined by the defense lawyer, and then sometimes, not always, sometimes the victim will testify in court and state what happened, and sometimes the accused will testify in their own defense, but sometimes not, and that's just based on the legal advice of their lawyer. So if the accused lawyer feels that person should not testify, if it would be detrimental to the case, that accused is not necessarily required to testify. There are some exceptions to what I just said. In some cases, the accused will elect to represent themselves. They don't have a lawyer. There's a number of reasons for that. Generally, most people would hire their own defense lawyer. In cases where they can't afford to hire a lawyer, legal aid duty counsel is available to provide a legal defense for that person. But in some cases, that person elects to not use legal aid or their own lawyer and just to represent themselves. So you don't necessarily need a defense lawyer to participate in a trial. However, obviously, someone who doesn't sit in a courtroom regularly doesn't really know the ins and the outs of the courtroom. And those trials are usually drawn out, and because that person is probably going off what they see on TV. That's not that common. I've seen it happen a few times, but it's not near as efficient as when lawyers handle the case. So after the trial, the judge will either usually reserve their decision. That just means they're not going to say that person is guilty or not guilty today. They're going to reserve their decision. They're going to go back, take some days, weeks, months, depending on the trial, review case law, review precedents, review testimony, and then they'll come to a conclusion about whether that person is guilty or not guilty. And after that, then, of course, if they are found guilty, it's into the sentencing phase. And I've included just an 11-minute video there at the bottom. If you want to watch that on your own, please do that. But we're not going to watch it on here. So I hope that's a fairly clear overview of the court system. Some sentencing philosophies, which we've already discussed. Retribution, deterrence, obviously, is another philosophy having someone look at someone else who's been sentenced and saying, oh, I don't want that to happen to me, so I'm not going to commit that same crime. Rehabilitation, all sorts of rehabilitation programs inside and outside of prisons. Obviously, just because people are sentenced to prison does not mean they can't rehabilitate. There are lots of rehab programs in prisons, also outside of prisons with respect to maybe it's anger management, maybe it's drug addiction, rehab, alcohol, anything like that. All sorts of different programs are available. Incapacitation, simply put, if someone is in jail, they cannot harm, in theory, they cannot harm people outside of jail. So just by removing that person from society for a given period of time, they're incapacitated, in theory, from harming people outside. We know people still can call the shots from inside jails with respect to gangs and that sort of thing. And also there can be inmate violence within an institution, but in general, incapacitation is a sentencing philosophy. And then restoration, restoring that person, making them ready to come back to society, able to contribute in a meaningful way, and hopefully not continue down this crime path. So those are some sentencing, just basic, broad sentencing philosophies from the court system. So in a nutshell, that is the court system. And then we're going to move quickly here into the third and final component of the criminal justice system, that is corrections. And so I put some responsibilities up there about the correctional system. Essentially, they are responsible for carrying out the sentences of the courts by administering a punishment. We're talking about the PCC, which is the Provincial Correctional Center, would be one example. The Oscana Center is another example of a correctional institution. That's a halfway house. If you're not familiar with Oscana Center, they're responsible for carrying out the sentences. If someone is sentenced to serve 2 years less a day at the provincial correctional carries out that sentence. Remember, if the sentence is under 2 years, it's a provincial sentence. If it's 2 years or more, that's a federal sentence in a federal penitentiary. Remember the difference there. I think we discussed that in the law lecture. But under 2 years is a provincial sentence, and over 2 years is a federal sentence in a prison, a federal penitentiary. The correctional system is also required to provide care and custody for accused persons. So they're responsible for feeding them, housing them, that sort of things, providing the necessities of life while they're in their custody. They are also required to protect the civil rights of convicted criminals. As I mentioned just a minute ago, violence can occur in prisons. We know gang members are in prisons, and people from different gangs are in prisons. So it would not be very responsible to put two people from opposing gangs in the same jail cell. So that's a consideration. They're also responsible to provide treatment and rehab for convicted criminals. Treatment, there's all sorts of treatment programs, medical appointments, that person needs to see a doctor, that sort of thing. That is all the responsibility of the correctional system. So, a few processes. Short-term detention of offenders awaiting a trial, and that is remand. If someone is on remand, they are, in theory, on a short-term detention of offenders awaiting a trial. Now, it says short-term. That usually means short-term. It can be months and months, though. Sometimes, like I said, it takes quite a while for a person to appear in a courtroom. So someone can be on remand for quite a few months up to leading up to their trial. Placement of those convicted in correctional institutions, placing them where they need to be in the correct institution, and not with people who they shouldn't be around, for instance, other gang members. We discussed this already, undertaking treatment options, education, and rehab services. There may be an appeal by an offender. So just because they're sentenced to a jail sentence, that, remember, usually if you go back to the slide with the court system, you can appeal the sentence. So that person may be back in court. Just because they're in the correctional right now, maybe they goes to an appeal court then that person is released. So that's obviously something to keep in mind. Pre-release planning and supports, these last two go hand in hand, supports for transition back to the community. It would be not a good idea to not pre-plan someone's release and ensure they have support systems in place. So just if someone's in jail for a substantial amount of time, do they have a support system? Or if they pump them out the front door, so to speak, are they going to be right back committing crime because they have no house, they have no food, they still have a drug habit, and so on. So supporting that person before their release is very important for hopefully limiting the recidivism rate, the reoffending rate once they are released. So those are all things to consider on the correctional end of things. So there's just an article there. I'm not going to open that video right away here. I'll let you do that on your own time. Try and wrap this up here so you can watch those two videos on your own. Just at the end here, a couple of notes and definitions. Discretion, we discussed discretion quite a bit. Discretion is applied at all three levels of the criminal justice system, which leads to filtering people out of the criminal justice system. So remember, discretion of a police officer, and last class I gave the example, if you watched it, where someone is pulled over for speeding. That police officer has the right to issue a speeding ticket, a fine, or maybe give a warning. So that's a very basic example of discretion. That applies to criminal offenses too. The example I gave was maybe an assault occurs where there's two friends and an assault did occur, but they don't want the other person charged. They don't want to go to trial. They don't want to testify. It's not a domestic nature. Maybe in some cases like that, discretion can be used to filter people out of the criminal justice system. So that's very important. The prelim we discussed already. The Crown must demonstrate there's enough evidence to proceed to a trial. And that's really just a little trial before the big trial. So just to see if there's enough evidence to actually go through the full-blown trial. Statutory release. This we didn't discuss yet, but federal offenders, so remember those are people serving 2 years or more, are released after serving 2/3 of their sentence. So that is an absolute. Stat release occurs at 2/3 of someone's sentence. So if they are sentenced to 3 years in a federal institution, they're getting out at 2 years. And maybe they're placed on house arrest or a period of probation, but very rarely does someone serve their full federal sentence. It's usually 2/3, so that happens all the time. A few other things we discussed. Aging out of crime. So that is, one's involvement in crime tends to increase throughout your adolescent years and then decline as one ages. So very rarely do you see a 70-year-old person doing break-and-enters to compounds. Most of the time, people age out of crime. The older one gets, statistically, they commit less crime. That is not true in all cases. It is not. It is. There are people who are well into their 60s and 70s who are still committing a lot of crime. Remember, crime does not necessarily involve property crime. It might be white-collar crime, which we'll get to at the bottom of this slide, but essentially frauds and that sort of thing. So, but generally speaking, statistically, people will age out of crime. We talked about the crime severity index last class, and that is an indicator of the volume and seriousness of crime. And remember, it's reported crime. So the seriousness of crime really involves looking at the potential jail sentence or how harsh the sentence is. So a city with a high high number of murders will have a higher crime severity index than a city with no murders or no violent crime. So it's really looking at the seriousness of the crimes, and that is the crime severity index. It's a very good indicator about what crime is occurring. Reported crime, remember, when we talk about this, I can't say it enough. It's reported crime. We discussed the dark figure of crime, which is the difference between the amount of crime occurring and what is reported to the police. So the crime's still occurring. We know it's occurring, whether it's 4 times more, 3 times more, 5 times more, whatever. A large number of crime is occurring, only a small portion of that is reported. So the dark figure is the rest of it, what is occurring but not reported. And then white collar crime simply refers to non-violent crimes committed for monetary gain. So those are your computer crimes, your frauds, your phone scams. You get a text message from something that looks official, WestJet, the Royal Bank, Netflix. We need your credit card number for some reason. Or there's always the classic, you've won a whole bunch of money, whatever it is, $1 million. But in order to get the $1 million, you need to transfer us X number of dollars, $1,000 to cover some sort of made up costs. You won $1 million for something you didn't ask, you didn't play the game, but they need some money up front to release this to you. Classic scam, right? Obviously that would never happen. The Royal Bank or Revenue Canada will never send you a text message saying, hey, we need your credit card number. That's not a thing. So that's white collar crime. That'll wrap it up here. So just in conclusion, remember there are three main institutions that make up our criminal justice system, those being the police, the courts, and corrections. The salient notion of the criminal justice system is it's about social control, formal social control, remember, not informal. It requires the application of ethical behavior and decision-making for all who work in those three areas. So ethics is a very big part of the whole system. Indigenous peoples have positively influenced all three institutions, as we've seen. And our system in Canada is based on a structural functionalist perspective. I wouldn't know that part. Remember, I read out to you what that means earlier, and our system is based on a structural functionalist perspective. So that, in a nutshell, is the criminal justice system. I know it's very broad. This is a 100-level class, and we're not going to get into those topics as much as I'd like to, because I find this obviously extremely interesting. But that is a very broad stroke on the criminal justice system. So remember, going forward here, next week is our last week together. We're going to look at restorative justice, and then we're going to have a review for the final exam. So with respect to the grading, as I mentioned at the beginning of today, I'm just waiting to hear back from the Department of Justice Studies. They were clarifying, like I said, 1 or 2 points, and I haven't got an answer yet. So as soon as I get that, I will post that to the news forum on UR courses. So be sure to check that regularly, and we will discuss it on Tuesday of next week when we get into restorative justice. Again, any questions, problems, or concerns, I'm here to help. If something is not clear, please send me an email, and we can either discuss it on email, or we can set up a one-on-one Zoom conference just like this where we can discuss. Sometimes that's easier than typing, because sometimes things get lost in translation when we type, as we know. So if you need help with anything at all, please don't hesitate to find me that way on email. So I think we'll leave it at that for today. I thank you again for tuning in. I will post this again to YouTube and then share the link with you later today. So if you would like to watch this again, or if maybe one of your friends wasn't able to make it here during class time, it's going to be on YouTube later. So make sure they know to check that out. I think we'll leave it there, and we'll chat with everyone next Tuesday. Thank you.